If you're watching this video, it's because you're interested in the subject of wills. So let's begin with the basics. A will is a document in writing signed by you that basically says who will look after or administer your estate upon your passing and who will receive your property. The document can also deal with some other subjects such as funeral arrangements or perhaps the designation of a guardian for minor dependent children. A will has to be signed by the person making the will in the presence of two other persons who act as witnesses. The one exception in New Brunswick is a document in your own handwriting, dated and signed by you. Even without the signature of two witnesses, it is considered a valid will so long as the probate court is satisfied that the document is in your handwriting. This is sometimes referred to as a holographic will. In many jurisdictions, these are not considered valid, but they continue to be recognized as such in New Brunswick. A will is not actually legally valid until the day you pass. Prior to that, you're free to make any changes to that document or even completely replace it by another will, so long as you have capacity. It is only the last will and testament that is considered the document that governs your affair. Some people wonder whether it's advisable to prepare your own will. There are will kits or blank will forms that can be obtained at a stationery store, which largely invites you to fill in the blanks. In circumstances where you merely wish to designate a surviving spouse as the executor or executrix of your estate and provide for them, following which perhaps adult children, a will of such type may be sufficient for your purposes. However, if you have first or second families, if you have children with special needs, if you need to appoint a legal guardian for minor dependent children in the event of you and your spouse passing, it is very advisable to have a professionally drawn will. One thing to remember, though, is a will only becomes operative when you pass. It does not say anything about the circumstances or who should look after your affairs in the event of your incapacity, such as through a trauma or a sudden illness. For that, you need to appoint somebody to be your personal representative while you're still alive, and it's typically done by means of a power of attorney. If you're curious about powers of attorney, why not watch the video on that subject on my channel? Thanks for watching. I hope that helps you to at least have the beginnings of the understanding of what wills are about.